Well, we felt that the court was very interested in the case and asked some very useful questions also to clarify the statements made by us. It has been a very long case, and a lot has happened in the jurisprudence of the court since the beginning of this case. So it was very important to today discuss where we stand today. And I was particularly pleased by the way that the court also very much focused on the specific situation of self-determination and of the manner in which the council, for example, considers the PKK. So I think the court I was pleasantly surprised by the questions of the court.
Three. I expect that the judgment of the court will be delivered in about 7 months. So somewhere, I think, at the end of 2020. Yeah, 2022. Yes, I think we expect that it will be very different. Why? Because I think the court will now address the substance of our arguments. In the 2018 judgment, the court addressed like the motivation of a decision, but now it has to go into the substance of all our arguments.
Results and impacts of the decision on the...
Well, the third case in many ways is very similar to the ones that we have discussed today. I expect to get a very thorough judgment in the cases that were discussed today. And then for the third case, the one that we started in 2021, probably that judgment will also be leading. And we will have, of course, to check what arguments are accepted or rejected in this case to see exactly how it is applied in the 2021 case. But I would expect this to be the most important judgment that will give the most details about how they look at the listing of the PKK.
The question is, will the European Union Council and Commission oblige...
Well, that is actually, I think, one of the questions that also the judge put forward to the Council of the European Union with respect to the 2019 measures to keep the PKK on the list, because then the court said, well, there was a judgment of 2018 where all the decisions and implementing regulations were annulled. You had to do something, actually, to comply with that judgment. And what you did is issuing exactly the same decisions and implementing regulations with the same statement of reasons. So the court asked that question to the council, and the council actually agreed that what they should have done is something differently, or should have asked a suspensive measure with the highest court.
Well, obviously, the court takes note of its own judgments in the Hamas and LTTE cases. And there are similarities in the arguments put forward. But I also think there are very important differences. And in particular, from what I can see, this case really shows that the Council relies on military actions to justify its risk of terrorism. And that is the main issue that we have argued about, that this is not sufficient. You cannot simply refer to these military acts, not without explaining why those are considered terrorism. And I expect that the court will have to take a decision on that. And they have made some preliminary decisions in Hamas and LTTE, but we have put forward that they have not yet made sort of the final step in asserting whether or not you can talk of terrorist acts in regards to such acts as the PKK is confronted with. Well, I think, first of all, it is important to keep in mind that because this has been such a long procedure, actually, I think both the Council but also we ourselves have at some points have to say, well, you know, what we said back then no longer applies, or in fact, in light of jurisprudence, we no longer discuss that. it was, to us, a very interesting discussion as to whether we were actually the lawyers that were supposed to do this, because we, of course, know very well that we are the ones that are to bring this case to court. And it was also, I think, very clear that the court also accepts us as lawyers and understands that we do represent the PKK. So to us, that was not a very major discussion, and I think that it was very, it will mean that the court has less to write down now that the council has also decided no longer to keep this argument. But I don't think it was a very difficult discussion. Well, I think that was one of the issues that the court really had an issue with, was that indeed, even though the court in 2018 said the decision is insufficiently reasoned, in 2019 the council copy-pasted it. And that is also why we said, well, at the very least, the cost of that procedure should be covered by the council, because we wouldn't have had to do that case if the council had amended its conclusions. Obviously, we are still discussing whether or not those decisions in 2015 and onwards were correct. And the fact that they were copy-pasted afterwards means that that discussion also applies to the 2019 decisions. But I think it was very clear, and also, for example, from the fact that the court asked us, like, you know, not only did you say it is a violation of the statement of reasons, but don't you really say that they didn't listen to the court? That, yes, that is what we say. And I can understand that the court also felt that, you know, they want to make sure that if they take a decision, it is actually listened to.
Mr. Abdullah Öcalan's approach, a peaceful solution approach, plus what does that mean exactly?
Well, it will be up to the court to decide in how far they take that into account. But we have, of course, argued that in light of those developments, the listing can no longer continue. And I think we did see a discussion take place where the council seemed to say that really for them there has to be a definitive peace deal to take an organization off the list. Where we put forward that, well, if you want to have a definitive peace deal, you know, that's a bit unfair, because if the other party doesn't want to play, and if the other party doesn't want to be a part of a peace deal, then you are continuing the listing, even though our client is very much trying to achieve that peace. Yes? Okay. Thank you.